Enrich, right? Probably said that wrong.
Alex Chavalowski for the people.
Mr. Overwater.
Sorry, Your Honor, this is Ken Overwater, Assistant Public Defender on behalf of Mr. Ehrenreich.
State your name, sir. Mr. Ehrenreich.
Can you state your name for the judge?
Yes, my name is Amit Ehrenreich.
Okay.
At the same time,
Right.
I do not have anyone representing me.
You don't?
No.
Okay. You
No,
don't want somebody representing you?
I will be representing myself, Your Honor, if I may.
Have you discussed that with Mr. Overwater of the Public Defender's Office?
I have not. I do not know Mr. Overwater.
Your Honor, if I may, I went to the jail yesterday to meet with Mr. Ehrenreich. One of the deputies brought him to the cell. He looked at me, and evidently he told the deputy he didn't know who I was, so he refused to meet with me. The deputy tried to encourage him to sit down and talk to me. He continued to refuse to do so, and then he left. Based on that, the information that I was given by the deputy I spoke with, as well as the allegations in the police report, I'm concerned that there may be an issue of competency. Obviously, I have not been able to speak to Mr. Ehrenreich, so I cannot verify that independently. What I was planning to ask for is for the court to admonish Mr. Ehrenreich to at least consider speaking to me and to adjourn the probable cause conference for that purpose. If he is resolute in his intention to represent himself and to refuse to speak with me, then I would leave it in the court's discretion.
If I might jump in, Judge. Torshio Feaster, Assistant Public Defender. Judge, I did represent Mr. Ehrenreich at a probation violation, a PPO violation about a week and a half ago. So he does know who I am. And at that time we spoke, he said he wanted to represent himself on the PPO violation, but he did want our office to help him on the new felony charge. So maybe he didn't speak to Mr. Overwater because he did not realize he's with our office. But I would, on behalf of Mr. Overwater, I think, ask for an adjournment and ask our client, please speak to him about this matter moving forward.
Mr. Ehrenreich?
Yes, Your Honor.
Did you hear Mr. Feaster?
I heard partially. One of the guards was speaking on his communication device, and I could not really hear what was going on.
Oh, okay. You had a hearing in circuit court on a PPO violation?
That is correct, Your Honor.
Okay. You remember the attorney that was representing you at that hearing, Mr. Feaster?
I do remember Mr. Feaster, and I believe the judge was Mr. Conlin, if I'm not mistaken.
That's right. Okay, that's right. So Mr. Feaster stepped in.
I cannot hear.
Can you hear me, sir?
Yes, yes.
Okay, Mr. Feaster just stepped in right now to let you know that Mr. Overwater, who you wouldn't speak to, that they're part of the same office. So you didn't know who Mr. Overwater was when he came to talk to you, but he and Mr. Feaster work in the same office. And I don't know if you were aware of that or not.
I understand what you're telling me, Your Honor. I understand. I was not
Okay.
aware of that.
Okay. So here's what, go ahead.
At the same time, Your Honor, I would appreciate at this point representing myself.
Okay. Here's what
I will mention, Your Honor, that at the circuit court, I spoke very clearly, and Judge Conlin, for whatever reason, postponed the discussion, or he didn't want to hear what. I'm not exactly sure. Bless you. I'm not exactly sure what went on. I admitted to having gone to that street where that person lives.
No, Mr. Ehrenreich, please don't say anything about the substance of the case. Anything you can be used against you. So please don't say anything like we discussed last time. Please wait and speak to Mr. Overwater and let him try to help you you're facing a 5-year felony.
Mr. Ehrenreich, if you don't understand what happened in court, it might be because you need the assistance of an attorney.
All right, Mr. Ehrenreich, here's what I'm going to do. I'm not going to rule on your motion right at this moment to represent yourself. What I want you to do is talk to the public defender, and after talking with the public defender, you can make an informed decision as to whether or not that's what you want to do. Okay? So I'll hear you out on it. It's just that I'm not going to hear you out on it today. I want you to talk with them and make sure that you're clear on where you're headed with this. Because it sounds like there's a lot that you're dealing with in terms of the PPO violation, this case, and it could carry some severe consequences. And I just want to make sure that you talk to somebody before you make that decision. All right?
Your Honor, I appreciate what you're telling me, and I understand everything clearly. At the same time, I have done almost nothing. I do not understand why what I did not hurt a fly. I did not.
Okay.
Cause
All
any
right.
harm.
Mr. Ehrenreich, I don't want you to say anything about the facts
Mr.
of the case.
Ehrenreich?
I will explain what happened and why you're in jail, what you're charged with. I'll explain everything to you if you will let me meet with you.
I do not wish to meet with Mr. Overwater, with all due respect to him.
Okay. All right. So, Mr. Ehrenreich, let me ask you this. You met with Mr. Feaster, correct?
I've had a video conference with him. I have not met with him in person.
Okay. All right. So I don't know, and I'm not going to interfere on who's going to meet with whose cases are assigned. The public defender's office now knows that. So it might be Mr. Feaster that you meet with. Okay. But in any event, particularly given what you said, that you're not sure why you're there or anything else along those lines, I want you to meet with an attorney that can explain that to you. All right. And then you can make the decision as to whether or not you want to go forward and how. Okay.
Your Honor, I understand the situation completely.
Well, no, you don't, because you don't know what you did that has you where you are. And you just said that to me. So you don't understand it all. And I've got to make sure that you do. And one of the ways I can make sure that you do is to have you talk with somebody so they can at least explain why you're where you are right now. Okay? And that's so, Mr. Ehrenreich, I'm going to do that, and I'm going to do it to protect your rights. So I'm going to tell you that when they come down to talk with you, I need you to talk with them at least, okay? And then we'll come back, and then you can make your decision about what you want to do.
Your Honor, I respect everything that you say. At the same time, I do not wish to waste anybody's time. And from my point of view, I'm willing to proceed. I know exactly why I'm in jail. I know what I've done. I know what I didn't
Well,
do.
you just told me a little while ago, Mr. Enright, you didn't know.
No,
And now you're telling me you know. That leads me to believe that I may have to order a competency on you. I don't want to do that. Okay? Mr. Ehrenreich, I'm going to implore you to speak with an attorney first. Because you're telling me one thing, then you're telling me something else. And that may lead me down a path that I don't know that you want to go to or go down.
It says the connection is unstable. I'm not exactly sure. Mr. Gibbs.
Still hear you.
Okay. Your Honor, can you hear me?
I can hear you.
Oh, all right. It just displayed the connection is unstable. I just want to be very clear on what I said in order to avoid any confusions or misunderstandings. I know wholeheartedly why I'm in jail. I know what I've done. I'm willing to hold myself accountable. I'm willing to hold myself accountable for what I've done. The thing I do not understand, and that's what I meant when I communicated that, I do not understand how what I've done is got to a point where if I feel felony is being...
Mr. Ehrenreich, that's
Yes,
the problem. That's the problem. You need somebody to explain what, if you're saying you did something,
Yes.
and I don't want you to say what you did. If you said you did something, but you don't understand what the consequences of that are, that's a problem. And so I'm going to get an attorney to you. I'm going to ask you to speak with them so at least they can explain that to you. Then you can make your decision about whether you want them to help you and represent or whether or not you want to do it yourself. But Mr. Ehrenreich, I'm done. That's what I'm going to do. It's up to you now to talk to the attorney so that you have as much information as you want. If you don't want to do that, you might want to tell me now so I can order a competency.
I rather represent myself. I rather not speak to an attorney. I do not feel that competency is needed. However, if Your Honor, if you would like to do that, it is up to you. You're the judge.
Oh, I am. So here's what I'm going to do. I'm going to order a competency a forensic evaluation, given what I've heard from the defendant on the record and what apparently is a confusion on a number of different levels. I'll set that competency hearing for.
You want to do 60 or 90?
60.
Tuesday, November 21st.
That'll be set for Tuesday, November 21st. November 21st, 2023, 9 a.m. Mr. Overwater, can you please prepare the orders for the court signature, please?
I will prepare that order. Thank you, Your Honor.
Thank you. Thank you, sir. Counsel, state your appearances, please.
Good, thank you for the record, Jonathan. On behalf of the people, good afternoon.
Good afternoon, Your Honor. Joy Gaines, Senior Assistant Public Defender, working on behalf of Mr. Caldwell. Sir, would you please state your name?
Sean Rudolph Caldwell.
All right. Date and time set for prelim. There is a motion. I guess you have defendant's response to the motion that I have in front of me, but there's a motion to proceed by forfeiture or pursuant to 804B6. So again, I just want to make sure I've got this right. So if the prosecutor points out 3 calls, says here are these 3 calls. Defense counsel can't double check those 3 calls, or as Ms. Gaines is trying to do in this case, give context to those 3 calls. She may not be disputing the calls at all, but she can't give context to them because in this mass of 100 calls, she's got to find those calls because they don't come over in order, right? I mean, they don't come over in some chronological order.
Not that I can ascertain. There's nothing that seems to me that there's any chronology.
So I see you shaking your head, Ms. Gaines. I just want to be clear. So if you click on the first link, that could be a call from, and then you click on the second link, those calls may be unrelated to, like, they're not chronological. It may not be that next call. It could have been a call way before.
And as it's stated in their motion, that, and I believe that this is common, that people, because they may only have so much money or whatever, use other people's numbers. There are clearly at least 2 that I'm certain are not Mr. Caldwell. But again, and
Are not Mr. Caldwell.
and this is Caldwell. I'm certain because it's a Spanish speaking couple and he's not. So that's in there too. And so because they're pulling from
His pen.
or I'm not sure, but whatever it is, because of the sharing, there are things that are completely unrelated to the case.
All right.
Besides the.
So even if I were right now to try to fashion an order to say provide the date and time for the calls that occurred within this particular date range. You'd have to go back and do that.
Yep.
And then get them to Ms. Gaines. Do you know the date range?
I do not know the full date range. I'm assuming it's from the time of.
Well,
It's the rest to our September 19th court date. But
and you would need all of those to place context, is what you're telling me. How long is it going to take you to do that?
For all, if I may just, I see the court's point, if I may just elaborate my point of view on it.
Sure.
Our motion makes mention of 3 calls up to August 15th. I think that August 15th, maybe a couple days thereafter, would really be the focus of, was there any wrongdoing from August 5th to August 15th, 17th? I think that's shorter.
I see what you're
We
saying.
get all the context that there would be, because we're not making mention of anything that happened after that. So whatever context might exist should have already been, logically would have already been, the context would be there within those calls.
Your Honor, that's nearly a whole month before the court date. That I think that in itself,
A month before.
for the court date where she was subpoenaed, Mrs. Caldwell was subpoenaed to appear on September 19th. How can we take a couple of phone calls
I see.
when it's more than a month before she's actually?
What's your date range?
So I would want it through the September 19th.
From August 9th through
I believe
August 5th
That's the date of the incident.
through September 19th. And that's the 100 calls. Basically,
I mean, if I,
give or take.
if I'm able to, reduce it down to her number, I mean, it will be, that means weed out the commissary phone calls, weed out when he's calling inmate information services, that'll take it down a little bit. We're probably talking about, at that point in time, maybe 60, 70.
Okay, so let's say there's 60 to 70. I mean, I think Ms. Gaines makes a good point.
Sure.
Up to the time that basically she would have been subpoenaed to appear. So those 60, how long did that take you to do?
The court gives me to the end of the week. I mean, I can really bust and try to get it done.
And then once that happens, then you, Ms. Gaines, have to listen to them, right? Formulate. Okay. All right.
Yeah, again, I would argue that, this is information that we should have been provided from the beginning. And that.
Well, I agree with you, except nobody up until today let me know that this was the process, that this was the stop, right?
I apologize. I didn't realize that my argument last time was unclear, because this is what I was arguing.
Well, you were arguing the context of it.
I could not tell the context because of the numerous calls, and that there's some in Spanish and that some is commissary. That
Right, but no, I understood the notion of the context of the call. What I didn't understand is you can't place the context because you don't know when these calls. I mean, I had no idea that you get 100 calls. You have no idea what order they're in. They're just coming at you. I think certainly if I had heard that, I would have been addressing that at our last hearing. When was that? Last Tuesday. So here's what I'm going to do. This is because this is the only way I can. Today's what, the 23rd? You need to get those done, and I'm not saying by the end of the week. I'm saying by the 26th, so that they're in Miss Gaines' hands. The 26th is about 3 days from now, by the end of the close of business Thursday, they need to be in Miss Gaines' hands. Miss Gaines is then going to have, and I'm just splitting the time frame in half. That's all I'm doing, folks. There's no magic to this. Then that way, Miss Gaines will have the 27th, 28th, 29th, and 30th. And at some point, she has to kind of communicate with Mr. Caldwell about what she sees so that, because he's going to, and I don't know this for sure, but he's also going to be giving context to what these calls mean with her. But she doesn't even have the order. And then I'll hear the motion and do the exam on the 31st. That's the best that I'm going to be able to do, folks, because I don't have the information here.
Just listen to those 3 calls. We just went through these yesterday. The phone call.
Sir, you got your law degree where? Where'd you get your law degree? Because you got one of the best attorneys in the county standing there next to you arguing this case, and you want to argue it yourself.
I'm just saying we have it.
Well, if you want to argue it yourself, then I'll not pay attention to what Ms. Gaines said, and then what I can do is I can grant their motion and we can proceed right now. Is that what you want to do?
I mean, that's about the most unfair thing that.
That would be unfair, which is why I'm not doing it.
Why are you threatening me with an unfair?
Because I don't know why you're talking to me.
This is most absurd.
Okay, all right. You're going to come this close to contempt. So I'm going to tell you just to be quiet. I'm 30 days. 30 days. He's got 30 days contempt. I told him to be quiet. He can keep talking if he wants. You want to keep talking? You want to keep talking?
You want to answer your question? You're asking me questions. Mr. Collins, why don't you want to answer?
He's got 30 days contempt. Take him out. I've given you the schedule. That's what we'll do. This is adjourned to the 31st. '26, close the business. Then you've got your argument, and this is adjourned to the 31st.
Just a moment.
Yeah, I just want to check one thing with these guys because I think there was a child care issue on the last day, and I just set this on Halloween, which means you got little ones, which means they've got to go places. That's going to be a difficult day for you guys, right? Is it going to be difficult all day for you, or what?
Handled early. I can.
No, I hear you. I hear you. If I could, all right. So I'm going to just do this way. And you're going to hate me for this, but that's okay. I've been hated before. I want, because these guys have been here 2 times while we've been arguing the motion. On the 31st, let's try to get them handled quickly in the morning. Okay. Or better yet, why don't we do it this way? Can they be on call?
I have no objection to that.
All right. Because that way, gentlemen, here's what I'll do. I'll hear the motion so you guys don't have to sit through this. And then you just be on call with the prosecutor. And if we need you, then we can get you down. How's that sound?
I don't mean to bemoan the point.
But you're about to.
I'm about to. You're giving him the 30. Are we in a rush to have it on the 30?
I'm in a rush to have it unless you guys can agree, because I'm sure Miss Gaines is going to try to get me to set aside that 30
I imagine you would.
So
Just trying to
Yes.
get as efficient as possible.
all right. His bond will continue. Thank you.
Nicole Hughes on behalf of the people.
Edward Drukas on behalf of Theopolis Fifth.
Mr. Smith, can you state your name, please?
Defies Smith. May I go in the breakout room with my attorney, Your Honor?
No.
Because I haven't.
Pardon?
Because I wanted to change some things I wanted to do. Me and him talked briefly, but I didn't get down to the A's and B's.
You didn't get down to what?
I wasn't able to tell my attorney exactly what I wanted him to do for me today.
Mr. Drukas,
Thank you, Your Honor. Actually, I did spend about 50 minutes with him here this morning. I did get the discovery. There are some video that I did start to go over with him. We also discussed some potential other video that may still be outstanding. And again, I was appointed yesterday. I'm looking to get an adjournment today, so I can fully go over the discovery with him and make a determination on what to do.
probable cause conference in this matter, November 9th, 2023, 9 a.m. Excuse me?
Can my attorney address my bond?
Well, he knows how to do that, but yeah, go ahead, Mr. Drukas.
Mr. Smith, I had gone over that with you. With regard to right now, we're not going to be addressing bond.
But I didn't want to, that's why I wanted to go into the breakout room so we could be on the same page.
I know. You don't need to go over this on the record, Mr. Smith.
Mr. Drukas, for the record, should defense counsel address bond, I will be asking the court to increase the defendant's bond. I understand why Mr. Drukas is making the decision he's making.
Okay, I understand. When is my next court day?
So are we done with the bond thing?
He ain't even address it.
Yes, Your Honor. I believe you had said November 9th.
Mr. Drukas?
Yes, Your Honor.
Do you want to address bond? He wants to address bond.
No, Your Honor. I'm asking for that XPC on November 9th.
Mr. Smith, the risk is if I address bond, I'm going to address all bond. I'm going to leave it where it is right now, but the people have made it clear that they're going to be asking for an increase. Your counsel is making a strategic decision not to address bond at this time, but if you wish bond be addressed, then
no, I did not want to postpone my preliminary. I wanted my preliminary to be, I didn't want to post no more probable cause. I want to move towards the preliminary. I don't want to have another probable cause conference.
Have you looked
over? That's why
over
me and my attorney not even on the same page. Me and my attorney,
Mr. Smith, did you listen to what your attorney said? There's video he still has to go through with you.
Yeah, but
so you want to have your preliminary examination before that happens? Because if I said it, I'm going to instruct the judge that not to adjourn it because you want to look at the video now.
To be clear for the record, the videos that we have turned over to defense counsel include the defendant brutally assaulting a victim. She was on the ground. He kicked her in the face repeatedly until she was left with what looked like a broken jaw to the police. She could not open her mouth and she could not speak, and she was rushed to the hospital. Defense counsel has requested an adjournment and requested that I look into whether there are additional videos leading up to the assault to help Mr. Smith explain to the court perhaps what happened leading up to that. I am more than happy to continue to a preliminary exam with the only evidence available being the brutal assault that this man committed on that woman. So, Your Honor, if we want to go to an exam, let's go, but I will not be getting those videos turned over before that exam date.
Hey, what do you folks want to do?
Breakout room with my attorney, Your Honor?
No, I already said no.
So
you wanted that you already spoke to your attorney. Your attorney had a very clear picture as to what he wanted to do. You come here this morning, I think, changing things. And I just want, if you want it set for an exam, I'll give you an exam. I'm assuming that setting it for an exam, Mr. Drukas, that would be over your advice to him at this point.
That is correct, Your Honor. Mr. Smith, let's proceed to November 9th and we'll continue to negotiate with the prosecutor.
No, I want to say it to the exam.
Okay, well, that's against my advice. Your Honor,
Hughes,
we can have an exam
Ms.
date.
Hughes, ready to go to exam this Tuesday?
We will do everything we can to get the victim there, and
All
hopefully,
right.
given her injuries, she's able to speak at that point.
All right. Well, we'll figure it out at that
Now, can
point.
we address
We'll start his exam.
Can we address?
We'll start his exam October 31st,
Can we address?
2023, 9 a.m. That's before me. Oh, joy. All right. Mr. Drukas, I
Yes, Your
realize
Honor.
your client's pushing you over your advice. Do you want me to address bond?
No, Your Honor.
Mr. Smith, you want me to address bond
Please, Your Honor.
over your attorney's advice?
Yes.
Okay, go ahead. Tell me what you want me to know.
Your Honor, my name is Theophilus Smith. I'm paranoid schizophrenic type 1, 2, and 3, and bipolar type 1 and 2. I had a rough breaking up, Your Honor. I knew I should have called the law. I should have called the police when he was making all them.
I'm going to stop you right there, Mr. Smith. I don't want to go into the facts of this case.
No, I just let me talk, Drukas. Please let me talk. It's between me and the judge.
Well, you can't talk about the facts of the case.
Your Honor.
Mr. Smith.
Yes.
Just because you're going over the advice of counsel, I'm just going to advise you that anything you say can be used against you. You understand that?
Yes, Your Honor.
Okay. I've given you your warning and admonition. Go ahead.
Okay, Your Honor. Well, pertaining to the case.
And I'm going to stop you right there again, Mr. Smith. I'd prefer that you not speak about this case.
But I'm asking you to address bond, and you're not doing nothing I want you to do. So let me do what I have to do for myself. This for me, not for you.
I know. And we talked about this. This is about
I know,
you.
but guess what? You're not listening to nothing I'm saying. I would rather have Lamus represent me. Lamus. Because you're not doing nothing I said. And me and you we weren't even on the same page. We weren't even on the same page before the meeting ended earlier. So just let me talk without you objecting to your own client. Can you let me
All right. Mr. Smith, you seem to know better. You go ahead.
Your Honor, the defendant made several death threats to me. Not the defendant, the accuser. I don't know how the accuser knocked on my apartment door.
And again, Mr. Smith, I'm going to reiterate that you should not be speaking about the facts of this case.
Okay, I'm not going to speak about the facts of the case.
Okay, thank you.
Your Honor, if you could please give me a personal reconduct bond. Your Honor, I'm not a flight risk. I'm going to be in court on Tuesday. If you can lower my bond or give me a PR, Your Honor, I won't speak about no more of the facts of the case until Tuesday. I'm going to respect Edward Drukas on that point that I won't speak on the case. But if you could just give me a PR bond or lower my bond, because my family is not wealthy, Your Honor. We are not wealthy, and I can't afford $50,000, no 10%. Your Honor, if you can please just give me a chance to give me a real lawyer. Give me a lawyer.
Real lawyer?
No, a lawyer. No, I don't mean. I'm not taking nothing away from Drukas. I'm not taking nothing away from Drukas, Your Honor. I just want to check.
Oh, okay.
I just want to be free, Your Honor, because I feel like I'm not even guilty of this. My grandfather got inside of me. My grandfather was talking to me. My grandfather.
Ms. Hughes, response to the motion to reduce bond.
Thank you, Your Honor.
And Mr. Smith, before you go, Ms. Hughes, Mr. Smith,
Yes,
I warned you. I told your counsel that if you ask me to address bond, I'm going to address the whole thing. So maybe when Miss Hughes gets done, I haven't made a decision yet, but maybe when Miss Hughes gets done, this bond goes up. I gave you that warning and you went ahead. So now I'm going to let the people give their version. Go ahead, Miss Hughes.
Thank you, Your Honor. The people are requesting that this court set bond in the amount of $250 cash only. Notably here, the defendant's bond is $50,000 cash only. This is not even a cash surety case, never mind a 10%, which I think is pretty telling given how unique that type of bond is. The defendant is on misdemeanor probation for use of cocaine. It was initially charged as possession of cocaine, and it was pled down to use. At the time of his arraignment, in this case, he was already in violation status of his misdemeanor probation. The defendant has a criminal history dating back, as far as I can see, to 2000, which includes a number of drug and alcohol misdemeanor offenses. He also has 6 assaultive felony convictions. In 2014, he was convicted of a couple of cases of R&O on the police. In 2019, he was convicted of felonious assault and CCW. In this case, this occurred in Miller Manor inside the apartment building, and the apartment building has cameras, in the hallway. This case came to the police attention because a neighbor in Miller Manor heard yelling in a hallway. He exited his apartment, went into the hallway, and saw the defendant standing over a woman who had been brutally beat. She was laying on the apartment hallway floor, unable to get away from the defendant. The defendant then fled, went into his apartment. When the police arrived, they first tried to make contact with the defendant. He refused to open the door, refused to provide his name, refused to cooperate with the police. When the police made contact with the victim, her face was so damaged that she could not speak. She could not open her mouth. The police tried to interview her, and she could not even remain conscious. They were able to get her to agree to a medical release, and by the time they presented the medical release to her, she was no longer conscious to be able to sign it. The report indicates that she had injuries to her nose, to her cheeks, and to her jaw. She was immediately rushed to U of M. I am still waiting on her medical records to determine the extent of her injuries, but based on the police report, the police believe that her jaw was in fact broken, which is why her face was swollen and she was unable to speak. Again, Your Honor, our request is $250 cash only.
Anything else from the defense?
I think enough has been said, Your Honor. Nothing further.
Court believes, and the court would find that the setting of under the circumstances of this case, that, and with all due respect to the magistrate, I understand what they were going through at the time, that the bond that is set at that time, court would find that under the circumstances of this case, that may have been an abuse of discretion. The court will increase the defendant's bond in this matter, finding that the defendant is a risk to the public, a clear danger to the public given the circumstances of what the court has heard. Defendant's bond is increased in the amount of $2,000 or $200,000 cash surety. Thank you.
I'll come and see you, Mr. Smith.
Thank you, Your Honor.
Court calls the case, People versus Raheem Bragg.